All right, welcome everyone. Tonight we have Andrew Miller from Oric Law Firm, and he's going to tell us everything we need to know about creating or starting an entity. Andrew, take it away.
Awesome. Thanks, Stan. Thanks everyone for having me. Yeah, as Stan mentioned, I am a startup and venture capital lawyer and with the firm that's headquartered out in the Bay Area called Oric. Uh, we specialize in representing founders, partnering with founders very early in the company's life cycle, and scaling with them, doing everything from incorporation to talking about how to organize stuff and work out founders' equity, early financing, late stage financing, everything from Series A down to, I think as far down the alphabet as I've made at this point is a Series H financing. And then, hopefully IPO or an acquisition along the way. And then anything that else that comes up in the life of kind of starting and scaling your company, employment, IP, commercial contracts. Um, I'm living and breathing this stuff every single day. For some reason, it really gets me excited. And so I'm kind of one of the probably minority of people that find this super interesting. So we'll do kind of a semi deep dive. We can't cover everything, but as founders, it's really important that you understand kind of the mechanics at least and know when to ask the right questions and know when to pick up the phone and get a lawyer involved, and make sure that kind of you're doing enough work up front to avoid any big issues down the line. Um, so, and we'll save most questions for the end, but if anyone does have, anything kind of as I'm going through this or if I'm going too fast, please don't hesitate to speak up. Um, First of all, everyone can see my screen. We'll start with that.
Yep, you're
Yes,
good to go.
so
Yes, awesome. Okay, still can see my screen?
Yep.
Perfect. All right, cool. All right, it wouldn't be a presentation by a lawyer if there wasn't a disclaimer at the beginning. So my firm makes me say this. This is technically not legal advice. This is just for your informational purposes only. That's my firm bio. All right. So this is what you've been doing. This is the fun stuff. You've identified a problem, you're obsessed with it, you can't sleep, you're kind of thinking about how do I deal with this. You find some really passionate people who share in wanting to solve that problem. You're working on a solution, you're building a minimum viable product, you're up late at night coding, surviving off a pizza and Red Bull, trying to get a product out into the market. And then you're starting to see a little bit of traction. You have customers interested. Oh, maybe I should go out and raise some money, and talking to investors. That's the fun stuff. The legal stuff is kind of the boring stuff in the background. And you're kind of asking yourself, is this something I really need to worry about, especially now when I'm just getting started? And the short answer is yes. Small problems, everything in corporate law is fixable for a price. And small problems at the beginning, very easy to fix. If you let them fester, if you kind of stick your head in the sand and don't deal with stuff until later on, they turn into very big problems and very expensive problems to clean up. Um, this picture is from the movie The Social Network, which is scarily like 14 or 15 years old at this point. I remember when it first came out. It's all about kind of all the litigation that Facebook went through early in its life. Oric was actually Facebook's first real law firm, and so the senior partners that I work with had a front row seat and kind of were in the arena dealing with all of this stuff. And had the Facebook founders done a lot of things earlier, kind of planned stuff out a little earlier or been thoughtful up front, a lot of that stuff could be avoided. And that's our goal is, we want to set you up for success early. We don't want legal to become a roadblock to closing your venture funding, getting acquired, doing an IPO. This is a picture from Beyond Meat's IPO. This is like 5 or 6 years old at this point. You look in the background, there is a very, very tired me after several days of not sleeping to get this thing to the finish line. But super fun, super rewarding. Company was, still a unicorn company, still valued well over $1 billion. I think at their peak, they were a $10 billion market cap. And you got to help them kind of along that journey. And so today's topic is really just getting your entity set up. And we're going to kind of start with the end goals. Uh, First of all, keep it simple. We don't want to do anything weird. We want a structure that's very easy to comprehend, easy for investors to understand, maximize your chances of getting financing, make the equity structure intuitive, make the governance clear, like who owns the decision making, how do decisions in the company get made. Uh, you're creating all this really valuable IP. We want to make sure the company that we create itself actually owns the IP. And then want to do a little bit of planning up front to deal with kind of the 3Ds of in the business context. It's business death, divorce, a founder breakup, or disability. If a founder disappears, or if someone's just at some point just not pulling their weight anymore, how do you deal with that as the company scales? There's usually some people that are really strong contributors at the beginning of the company's life cycle. They don't always scale up and are able to contribute at the same level as the company goes from Series A stage all the way to Series F or IPO. So now we're going to get into kind of the nuts and bolts of this, the corporate form. So you're going to form a company, and what does that actually mean? What corporate form do you pick? There's 6 popular options out there: sole proprietorship, partnership, limited liability company, which I'm sure a lot of you have heard of, corporation. Some of you may have heard of S Corp or C Corp. And your eyes start to glaze over when someone tries to explain the tax consequences of each to you. And then the last one that I do like to bring up, it's becoming more and more popular, is a public benefit corporation. So we'll kind of walk through the pros and cons of each of these. And if you're a solo founder right now, congratulations, you are a sole proprietor. That means you kind of just opened up shop and no paperwork filed. You kind of just started selling stuff, putting your product on the market and seeing what happens. Super easy to do. Literally don't have to file anything. You kind of just start, buying stuff and selling stuff. You control everything. It's just you. There's one layer of taxation, which means that all the money you bring in, you're gonna. So if I'm, let's say I've got a lemonade stand, I buy my lemons, my, cups, sugar, all that stuff. Everything that I buy, all the money that I go out spend to get that's my expenses. I sell it. Hopefully, I sell it at a profit. So any money left over after all those expenses is income to me, but I owe taxes on it. There's privacy involved because you're not filing anything. It's not always clear. Kind of the state doesn't always know what's going on or kind of what you're doing, so you can be under the radar a little bit. But the major issue with this is what's called unlimited liability. So if I sold a cup of lemonade that had something in it and someone got really sick, they can turn around and they can sue me as an individual. If I've got, assets like a house, like they could come after that. So super, super risky. And you can't really raise money as a sole proprietorship because it's just you. If you were to die or kind of just disappear, there's no real business continuity. You can't really continue the business without yourself. So great thing about this, simple. That's kind of the only really good thing about this, especially when you consider the unlimited liability aspect of things. And so if you're working with co-founders, congratulations, you are de facto a partnership. Again, really simple to form. You're partners, you have shared responsibility. You owe each other what's called a duty of good faith and fair dealing in legal speak, which means you have to treat each other fairly. Still one layer of taxation here, meaning that any profits you make, like that's income, that's income tax that you declare and pay. Also easy to form. Downside here again, still unlimited liability. If you're just a regular partnership, you're a general partnership, you and your partner are general partners, you are liable not only for everything that you do, but also everything that your partner does. And so if my partner goes off and sells a bad cup of lemonade, and the person turns around and sues the partnership, maybe my partner doesn't have a lot of assets, but maybe I've got a giant house. That person can come after me personally for my giant house, even though my partner was the one who screwed up. So big downside there. Um, you may have heard of limited liability or limited partnerships. Um, it's a state kind of sanctioned partnership where certain partners in the partnership who aren't responsible for managing the day-to-day aspects of the partnership can have limited liability, meaning that the most they're exposed for any sort of lawsuit against the partnership is the money that they put into the partnership. All their other stuff can't be touched. Every partnership still needs a general partner, and that's general partner is still has unlimited liability. So a downside for that as well. Um, Interestingly, most venture capital funds are actually organized as general partnerships or as limited partnerships, and the fund managers themselves are general partners. But we'll save that. We'll save VC fund structuring for the next workshop after you've all exited and have tons of money and turned into venture capitalists. This is one that almost everyone's heard of. This is probably if you kind of ask some random person on the street or ask an accountant, like they'll say, just form a limited liability company. Um, this tries to combine a lot of the best aspects of partnerships and corporations, which we'll get to next. You file a document with the state. You would have a contract with you and your co-founders. It's called an operating agreement. Um, there's a lot of flexibility allowed here. There's still one layer of taxation. That duty of good faith and fair dealing that I mentioned earlier with partnerships can actually be waived. Um, if you're starting, I don't love this term, but like a lifestyle business, if your goal is to maybe not raise venture capital, but you've got, you have like a chain of coffee shops or car washes or something, where you're going to start generating profits right away and you don't need to take a ton of outside investment. An LLC is actually a good choice, a good entity to go with. Super flexible, optimizes for the best of kind of both worlds. Some downsides of it is it can be surprising because there's so much flexibility involved. They can become very, very complex to manage very quickly. And you as a manager, a member of the LLC, or if you admit kind of other people, you bring on employees and you want to give employees equity in the company, it becomes a little bit more challenging, especially from a tax perspective, if you're using an LLC. And these, I have seen venture capitalists invest in LLCs, but it's very rare. Because this is what we call, one layer of taxation, a pass-through entity. VCs don't like that because profits are then immediately distributed to them, which can create issues because VCs, a lot of their investors are, pension funds or foundations, nonprofits. They can't recognize profit, can't receive the profits of a for-profit entity. So that's one of the reasons that VCs generally don't like LLCs. Doing good so far? I know I'm talking fast, so. All right, corporations. Two types of corporations that you'll hear about, an S Corp and a C Corp. They're basically the same thing except for their tax status. So an S Corp has this, what we've been saying, a one layer of taxation. So any profits get distributed out to you, the stockholders, and you pay income tax on that. There's no separate corporate tax that's paid. That's really the one big benefit to an S Corp. But in the 10 plus years that I've been doing this now, I've never once dealt with an S Corp because there's so many other headaches that come along with them. You can only have 100 stockholders in total, which isn't really that many if you're trying to become a big kind of growth company and try an IPO. They all need to be individuals, meaning that venture funds or they're funds or partnerships, not individuals. They can't invest directly, and you can only have one class of stock. And venture capitalists will get talk about it a little bit later. Will always take something called preferred stock, and so it's not really a vehicle that they can invest in. And yeah, with the rise of LLCs and the popularity of LLCs in particular, like S Corps have really kind of gone by the wayside. Like I said, I've never seen one in my career. And now C Corps. This is the kind of gold standard for a company that the goal is to raise venture capital and go on and dominate the world. You've got the limited liability protection of a corporation. You have unlimited growth potential. If you're a C Corp, you can qualify for something called qualified small business stock, which has huge tax benefits to you as a founder and to your early investors, where you can essentially pay up to no capital gains tax up to a certain limit. So super valuable from that perspective. The C Corp does have what's called double taxation, which means, if the company generates a profit, the company itself is taxed on that profit. And then if the company distributes cash to its stockholders, they declare what's called a dividend, the dividend is then taxed. So that's two layers of taxation, which is why some people shy away from C Corps, or if you're the average advice you would get from your kind of average accountant off the street is to go with an LLC, is because over a C Corp is because of one layer of taxation versus two layers of taxation. As a startup, though, the fact of the matter with most startups is for most of their life, they are wildly unprofitable. And that's why you see companies raising money and doing a Series A round all the way through a Series H round as they keep needing to raise cash from investors to grow their operations, because they're not profitable yet. They're not generating enough cash flow from their core operations to support the growth of the company. And so kind of the real wealth creation that happens from a venture-backed company is the increase in value of your stock, and not kind of trying to pay out profits or distributions or dividends. One last thing I'll mention, because it also is growing in popularity and maybe some of you are interested in it, is what's called a public benefit corporation. The exact same thing as a C corporation. The only difference here is a C corporation, or kind of your generic corporation. You as a director or officer of the company, as an owner of the company, have a duty to maximize the value of the stock for all the stockholders. That's kind of the one thing you really technically need to be focused on. And if you're deviating from that, you kind of risk being sued by your stockholders because you're not maximizing value. If you are organized as a public benefit corporation, you're allowed to consider other interests and other stakeholders as well, and have a declared public benefit, kind of a societal good that your company exists to achieve. Not super hard to do. The one big thing that people need to pay attention to is if you are a public benefit corporation, every other year you need to distribute a report to your stockholders on how you're achieving the public benefit that you said you were setting out to do. These are becoming more and more popular. One of our big clients in the AI space, a company called Anthropic, is actually organized as a public benefit corporation. So if you pull their what's called the certificate of incorporation, you'll see, it's instead of an Inc., it has a PVC, and then one of the first paragraphs in that document is their stated public benefit. All right, so those are the types of forms of corporate entity that you can form. You've got, in theory, 50 different jurisdictions, 50 states where you could go form these. Each state has its own set of corporate law. But everyone has, over kind of the course of the last 150 years, gravitated towards Delaware. Delaware is considered the kind of gold standard, and the gold standard for a venture backable entity is a Delaware C corporation. So everyone always asks, why Delaware? And part of it is the long history. They have a very well-developed set of case law. If you all remember from civics class, or if you've taken like an intro to law class, case law is, people sue each other, they go to court, the judge renders a decision, and that decision and the reasoning behind the decision help become part of the law going forward, and they help inform how people behave going forward. So Delaware has a specialized business court called the Court of Chancery, and all they do is deal with corporate law matters. And the judges on the Court of Chancery are very specialized. They've got a deep understanding of this. And I'd much rather bring, if I have to bring a case, I'd much rather bring it before the Delaware Chancery Court than like a random judge in Jefferson County who, maybe was an English major, has no real business experience, and does, most of his time is dealing with like criminal law cases or divorce court stuff. Um, Delaware also has a very sophisticated corporate code that actually gets updated by its legislature annually. So they've really kind of created a market around this and really specialized around this. And so that's why investors like it. That's why companies like it, is there's a lot of certainty. Everyone really understands it. And it's kind of the most important thing from a business perspective is like founders don't really care what the rules are. They don't care what the rules are. They just want to know what the rules are and have certainty around that so they can make kind of sound decisions and understand what the playing field is. And that's really why Delaware has come to dominate the world of corporate law. Anyone who's been following the news recently might have some questions around this. Anyone know who the guy on the left is? Feel free to shout it out if you know. All right, the silence is a good thing. That's Ken Mullis. He founded and runs an investment bank. And if you don't know who he is, that means we're no future investment bankers here, which is good. Not to knock investment bankers too much. Everyone knows the guy on the right, I'm sure, Elon Musk. Elon has been in front of the Court of Chancery in Delaware a lot recently. He went to go buy Twitter, then he tried to back out of buying Twitter, and then ended up being forced to buy Twitter based on Delaware law. He was promised a huge pay package by the Tesla board of directors that wasn't properly approved by stockholders, that then the Delaware courts rejected, prompting him to then post on now X, never incorporate your company in the state of Delaware. So there has been a lot of rumbling recently about this. Some other big companies like Facebook Meta is now considering reincorporating, I think, in Nevada. Other companies have reincorporated in Texas and Nevada, saying that Delaware kind of corporate law isn't what it used to be. Jury's still ultimately out on this. Some people have, think that there's been what we call a lot of legislating from the bench in Delaware. But the Delaware legislature has also been very quick to act and change the corporate code to kind of mitigate some decisions that have recently come out that kind of called into question whether Delaware is still the best place to incorporate your company. So our standard advice still is, go to Delaware, incorporate in Delaware. That's kind of going to make you the most investable from a legal perspective. All right, so we've talked a lot of theory. We get it now. Delaware C Corp, that's the way to go. Big question, how do we just get this done so we can go back to building our company? And here is the list of all the documents that you're going to need and that you're going to have as part of this. So the first thing you're going to do is you're going to file a couple pieces of paper with the Delaware Secretary of State. That's your certificate of incorporation. It's the main governing document for your company. When you first start, it's a couple pages long. After you do a couple rounds of venture financing, it ends up being like a 30-page document. One of the most important things, the thing that most founders care about, is this is where you figure out how many shares the company is allowed to issue, and the types of shares that it's allowed to issue. Every venture-backed company will have common stock. That's what you as the founders will receive. And then preferred stock is what the investors received. And so with every financing, you'll have a new series of preferred stock. So Series A preferred stock, Series B, Series C, and so on and so forth. But when you first get started, it's a pretty simple document. You just have common stock. The person who actually files that with the Delaware Secretary of State, whoever emails it in or submits it in via fax, that person is the incorporator, and they're actually named in the certificate of incorporation. So they've got, the first big job is, they form the company. Once the certificate of incorporation is submitted to Delaware, your corporation exists. And now the incorporator needs to sign a piece of paper that does two things. And that is appoint the board of directors. The board of directors is the main governing body of the company, and then adopt the bylaws, which is a more detailed set of rules for how the company is going to operate. Once you have your board appointed, they're going to sign an initial board consent. There's a lot of corporate formalities like authorizing the company to open a bank account and to keep what's called a minute book. The more important things that you'll see in that initial board consent are they're going to appoint the officers of the company. Every company needs a president and a secretary, and then also every company you typically see will have a chief executive officer, a CFO, a CTO. That's when those officer appointments typically happen. Oh, did someone have a question? No, just a random. All right. The other big thing that happens in the initial board consent is the board will authorize the initial issuance of stock to the founders. So that's the first step in making sure your stock's properly issued, is the board approves the issuance. Once the board approves the issuance, the founders will sign what are called stock purchase agreements. You will actually purchase your stock from the company. You can either do it for cash, and the initial value of the stock is always a fraction of a penny, or you can do it by assigning. You've been creating all this intellectual property. You can assign all that intellectual property to the company in exchange for your stock. That's how you can pay for your stock. And once the stockholders have the stock, they'll sign a stockholder consent that really does two things at the beginning. It approves an agreement that's called an indemnification agreement, which the officers and the directors of the company will sign. That agreement basically says that if the officers and the directors get sued by someone while acting in kind of their capacity as an officer or director of the company will stand in front of them. They'll defend that lawsuit, and they'll kind of pay any damages that come out of that lawsuit. So that's the first thing the stockholders will approve. And then every company I've seen that's venture backed will typically have an equity pool they've set aside for new hires. Companies don't have a lot of money early on. They can't pay high salaries. It's hard to recruit people away from Google when they're making $400,000 a year. But if you can say, hey, early stage company, really big, opportunity here, we can give you some stock in the company. So we can't pay you much, but here, take some stock, and hopefully it'll be super valuable in a few years. So that's a helpful way to recruit people. So you'll set up that equity pool, and that's one of the second thing that the stockholders will initially approve. As the founders, you'll also sign what are called confidential information and invention assignment agreements. You will also have every consultant, advisor, employee sign some variation of this agreement when they join the company. This is a very important agreement in that it says that any IP you've created while providing services to the company is owned by the company, and any IP you create going forward is owned by the company. One of the first things that we look for in venture capital due diligence is, does the company actually own all the IP? And one of the ways we check that is to see, hey, everyone who's done something for this company, have they signed this invention assignment agreement? I mentioned the employee equity plan, the pool. There's a bunch of forms that you'll adopt with that. It's called the stock plan, and then you'll have agreements that you'll use to issue stock and options under the stock plan. And then once you're done with all of that, you'll get on the IRS's website. You'll file for what's called an EIN, which is basically a social security number for your corporation. You can then turn around, you use your EIN and your certificate of incorporation. You go to whatever bank you want to bank with, and you can open your bank account. There are a few other filings that you would do, and then kind of you're incorporated, you're off to the races, and you can get back to all the fun stuff of building your product, getting customers, getting investors. One thing that I didn't include on that list, because I really wanted to make sure we called it out by itself, is always, always, always file your 83B election and file it on time. Now, everyone's probably asking, what the heck is an 83B election? When we form companies and when we bring on founders and we bring on early employees, we always recommend that when you give them equity, when you give them stock, that you subject that stock to something called vesting, which means that they get their stock up front, they own it, but if they don't stay with the company for a certain period of time, they have to give that stock back to the company. And when you do that, it has a bunch of tax implications. And the key thing to know here is that if your stock is subject to vesting, you want to file an 83B election with the IRS. And you need to make sure that you file it within 30 days. This is, the one thing that is really not fixable from a corporate law perspective. And it can create a lot of tax issues and be very, very, very expensive to deal with later on if you blow this filing. So if you take away nothing else from this workshop tonight, take this away. It's file your 83B. And it's in red at the bottom here again. I can't reiterate it enough. File your 83B. So we've gone through the mechanics of forming a corporation. Now there's some strategic considerations. So it's like, okay, we get the paperwork, we get that's all that stuff is done, but how do you decide how to split up equity between founders? There's nothing really formulaic about this. There's no right answer. But what we will typically see, or kind of typical consideration we say advise founders to go with is who's going to provide, among the founding team, who's kind of most important for providing value going forward. Don't be backward looking, be forward looking and allocate the equity accordingly, whether it's 60-40, 50-50. There's always some risk with 50-50 because then you have, a deadlocked stockholder pool. But that's kind of what we would consider is, think about kind of contributions on a go forward basis. And then you'll carve out part of your part of that equity for future hires. And typically we see companies reserve anywhere between 5% and 20% of the company for the employee equity pool. Founders will often ask us, well, how much should we do? And the consideration there is look at who you already have around the table, kind of who's the founding team, what core skill sets do you have, and what's missing? Who are you going to have to go out and recruit, and when are you going to have to recruit them? If you need a really strong technical founder for something that you're doing, or that first employee needs to be an excellent technical hire, because your founding team doesn't have you understand the market or the business that you're going in, but you don't have anyone that can has the right tech requisites to build the product. You're going to want to reserve a little bit more so that you can recruit the right person into the company. If you've got a lot of the talent you need kind of for the first 18, 24 months of the company, then you can go with a smaller pool, knowing that you don't need to hire a lot of really specialized or talented people right off the bat. As I said in the last slide, always, always, always subject your stock to vesting. That way, if someone leaves early on, they don't take all that stock with them. And always, always, always file your 83B. So now I'll be done harping on 83Bs. So I mentioned in the running through the documents, this thing called the board of directors, the board consent. Who are the directors? And the directors is really the governing body of the company. The stockholders, the owner of the company, will elect the board of directors, and the board's job is oversight of the company on a more day-to-day basis. The board's job, to be really cynical, is to basically hire and fire the CEO and make really important key material decisions for the company. Anytime you look to raise money, the board will be involved. Anytime you look to grant equity, the board will be involved. Any multi-million-dollar contract, the board is typically involved, and the board you want to meet regularly over the course of the year for the company. You'll have board meetings, and that's where business strategy that has hashed out, important decisions will be made. Every corporation, every Delaware corporation needs at least one director. You can, in theory, have as many as you want, but early on, 1 to 2 directors. You want to be very careful adding people to your board. It's going to happen over time. When you bring on venture investment, your investors are going to assist on a board seat, usually with each round. So kind of be cognizant of that. Ideally, you have an odd number of directors, so you don't have any sort of deadlocks at the board level. And like I said, stockholders ultimately are the ones who elect the board. So have control as a stockholder. You have kind of control over who sits on the board. The board hires and fires the officers of the company. Like I said earlier, you need at least a president and a secretary, CEO, CFO over time. And the officers, their job is really the day-to-day management, hiring, kind of executing on business strategy. When you first, if you're a solo founder, you might say, oh, I don't to have like another person that I can be like the secretary or whatever. Not a big deal in Delaware. One person can hold all the officer positions. We do see that very, very often. Even when there are multiple founders, maybe there's one founder who's kind of more the administrative person, and they end up taking a lot of the officer roles because they're going to be kind of more the business administrative person, and the other founder is more the technical founder. Stockholders, these are the owners of the corporation. So you maybe have like a Robinhood account, you trade stocks. That's kind of what you're trading is a stock is just a claim on the future value of the company, and it's also a claim on the governance rights of the company. So you get a claim to the company's profits, and you also get to vote based on the number of shares that you own. Mentioned earlier, different shares or different classes of stock exist in corporations. You'll be issued common stock. Your investors will take preferred stock. You can get all sorts of crazy complicated with founders preferred stock, or maybe you've heard of like super voting stock. Happy to talk with anyone offline on all that stuff, but again, the goal here is keep it simple. You're going to start off with one class of stock, common stock, and that's what everyone's going to get to start with. And then as you bring on investors, you can worry about stuff like preferred stock. Almost done, I promise. One important thing to remember when you form a company and as you start to bring on investors and more and more stockholders is, if you're a director or an officer of the company, is you owe the company and the stockholders what are called fiduciary duties. And as a corporate lawyer, this is where I spend a lot of my time advising clients is how to carry out their fiduciary duties. And as a fiduciary, your job is to act in the best interest of the company and the stockholders to maximize value for the stockholders, not to act in your own self-interest. As a founder and you're kind of one of two or one of three stockholders, you're kind of one and the same. Like what's good for you is good for the company generally. But as the stockholder base grows, like there can have divergent interests between the founders or between the officers and the directors and the stockholders as a whole. There's really two duties within fiduciary duties. There's a duty of care and oversight, which effectively means pay attention, be thoughtful, actually kind of look at the financial statements, keep good financial statements, do your research, do your diligence, be thoughtful in executing on strategy, don't break the law, don't commit fraud. And then what's called a duty of loyalty, which is effectively no self-dealing. Like don't hire your brother or your mom or your dad, or if you need to have a really good reason to. Don't pay yourself an exorbitant amount of money, or don't kind of give your other side business contracts with kind of your corporation. So that's kind of where the duty of loyalty is often implicated. And a lot of stuff that we do deal with is kind of where because a lot of venture investors do take a board seat and they're also investors in the company and looking to put more money in the company. We often see a need to help analyze cases where the duty of loyalty is implicated and how to navigate to make sure that the companies stay on the right side of that, the directors stay on the right side of that. All right, that was a lot. We're pretty much at the finish line. Some resources for you as you think about to get started. It's like, okay, how do I actually form a company? Or, if I need to read up more on kind of everything that I just flew through in the last 37 minutes, here's where you can go. Selfishly, our firm, we have a great website called Oric Tech Studio. There's lots of videos on there. We open source a lot of our documents on there. There's some great articles on there about how to start your company, things like granting equity to employees or how to hire or fire people. Super valuable there. if you're ready to go and incorporate a company, you can always hire a lawyer. I'm always happy to work for you and help you incorporate your company. But if you're very budget conscious, you're not ready to pull a trigger on a lawyer just yet. There are two ways you can incorporate your company and trust that it's done right if the goal is to raise venture capital. One is a company called Clerky. Um, Clerky is actually used by, there's an accelerator in the Bay Area called Y Combinator that I'm sure many of you heard of. They're kind of like the startup school, or kind of the best accelerator that's out there. Stripe went through them, Airbnb went through them, Deal went through them, Reddit went through them. So a lot of kind of the marquee tech companies that you hear about have some connection to Y Combinator, and they refer a lot of their companies to Clerky. Clerky was actually spun out of Oric maybe about 10 or so years ago, and you can go on there, pay like $1,500, input kind of how your founder equity splits are going to work and all that, who's going to be on the board, who's going to be the officers, and it will take care of all the incorporation stuff for you. Stripe, another company that's out there, has a product called Atlas, very similar to Clerky, just a different option. The goal there is to set up a company with the idea that you're going to be venture backed. So another great kind of cost effective, very easy way to incorporate efficiently. Y Combinator, I've got the QR code for Y Combinator's website on there. As a founder, I would recommend going on there and watching their startup school, how to start a startup series on YouTube. The founder of Y Combinator, this guy Paul Graham, has written a number of essays that I think are very much worth reading. Their the former head of Y Combinator is Sam Altman, who now runs OpenAI. So again, just wealth of really great resources for starting your startup, not just on the legal side of things, but just kind of the strategic side of things as well. And then the last one I'll mention is, once you've got your company up and running and you're bringing on stockholders and investors and you're giving equity to employees, you want to make sure you keep track of it all. And you could do it on like an Excel spreadsheet, but that becomes very onerous very quickly. And so we call this the cap table. The cap table is who owns the company and how you're tracking who owns the company. And most of the clients that I work with nowadays are on a platform called Carta, which is a cap table management platform. So I think they're free for just getting started. I think for the first 25 stockholders you have, they're completely free. Then after that, you have to start paying. But they on their website also have a lot of really great articles on stuff like incorporation or equity compensation, how to give employees stock, and kind of how to think about all of that. So yeah, another really, really great resource for you. And with that, I promise I am done talking for a little bit.
Fantastic. Andrew, thank you very much.